The letter on my kitchen table. According to the HOA letter sitting on my kitchen table, my family's orchard no longer fully belonged to me. That's what it said. Not in those exact words. But that was the meaning. 85 acres. 3 generations. A deed going back to 1937. And some woman named Diane Holcroft had decided, apparently, that a neighborhood HOA had the authority to observe. The mistake buried on page 2 of that letter would eventually cost her $67,000. She just didn't know it yet, thought what she was trying to take my grandfather planted those trees during the Great Depression. He came from eastern Tennessee with a mule, a strong back, and the kind of stubbornness that doesn't ask permission. He cleared the land himself, put in the first 4 rows by hand. By the time he passed the deed to my father, there were nearly 400 apple trees and a cider operation that ran every October. Without fail, my father ran the orchard for 31 years. And somehow, Diane Holcroft thought a neighborhood HOA could simply absorb it. My grandfather planted those trees so that something he'd built with his hands would still be standing long after he was gone. It was standing, 85 acres of it. And Diane Holcroft saw it as a line item on a zoning map. That's the part that still gets me at first. I told myself it had to be a clerical mistake, a boundary error, something that would get sorted out with one phone call. 6 weeks later, strangers would be walking my property with survey equipment. And Diane would be telling a room full of neighbors that my family's land was hers to reassign. But I'm getting ahead of myself. The HOA that grew too big for its boots, the subdivision called Sunridge, went up about a half-mile down the road in the mid-1990s. Nice enough neighborhood. We'd always been on good terms. We from the driveway, that kind of thing. My land was never part of their HOA, never signed a document, never paid a dime in dues. We were adjacent landowners. Nothing more. That had been true for nearly 30 years. Then the board voted to expand community jurisdiction. It passed at a Tuesday night meeting. 12 people in a church fellowship hall. Bad coffee. 20-minute discussion. The kind of thing that sounds administrative until it isn't. I didn't pay much attention. That was my first mistake. Because what I didn't realize was that Diane Holcroft had been waiting for exactly that vote. She came to my gate 3 days after the certified letter arrived. She showed up in person, not at my door. At my gate, standing there with a clipboard, a laminated HO, a badge, and the flat confidence of someone who has already decided how the conversation ends. "Mr. Calloway," she said, before I'd even spoken, "I'm glad we can connect in person. Most people cooperate once they understand the process. Most people cooperate." That was her opening line. I asked her what process she was referring to. She flipped to a tab page on her clipboard. She had it tabbed, like she'd prepared for this meeting and explained that under. The HOA's shared agricultural access provisions, any working orchard within the expanded jurisdiction, was now subject to community use agreements, access pathways, water rights review. Then she said, and in some cases, seasonal community enjoyment rights. I asked her to repeat that. Shared seasonal enjoyment. Residents within the jurisdiction have the right to access working agricultural land for community enrichment purposes. Apple picking, that kind of thing. I stared at her. She held eye contact and smiled. This woman was standing at the gate of land my grandfather broke his back to clear. Land that had fed my family for 3 generations. And she was telling me with a straight face that the neighborhood had the right to come pick our apples. I told her very calmly that my family had held this deed since 1937, that I had never been an HO, and that nothing she was describing had any legal bearing on my property. She wrote something on her clipboard. "We'll be in touch, Mr. Calloway. The formal review period closes in 30 days. And she walked back to her car. Then the flags appeared. I found them on a Monday morning. Orange survey flags. A straight line of them running along my south fence, planted 4 feet inside my property line. and two men in yellow vests were pacing the row with measuring equipment, making notes like they had every right to be there. Seeing those flags inside my fence line made my stomach turn in a way I hadn't felt since my father passed, and I realized it was just me and the land now. I pulled over, got out slowly, walked up to them. Who authorized this survey? One of the men checked his clipboard. Sunridge HOA, verifying expanded boundary lines per Amendment 14C. I told them to pack their equipment and leave immediately. They did. The flag stayed in the ground until the next morning. Like a message, the letters kept coming. The stakes kept rising. 2 weeks later, the second letter arrived, longer, more formal. Community jurisdiction boundaries as redrawn per amendment. 14. Property compliance review, formally. Underway and buried near the bottom, a warning that failure to cooperate could trigger restricted access. Provisions on my eastern gravel road, the road my harvest. Trucks used every single October. They were threatening to block my harvest road. Called Tom Briggs that evening. Tom's been on the adjacent parcel 22 years. Weathered face, quiet voice, the kind of man who measures his words like he measures fence posts. He'd gotten a similar letter. His 12-acre horse pasture was apparently violating community sightline standards. Ray, he said, after a long pause, what in the world is happening over there? I didn't have a good answer yet. She was already celebrating my neighbor Linda Schuster called the following week. Linda doesn't miss much. She'd been at the Sunridge community meeting the night before, the one I hadn't been invited to. Ray, she stood up in front of the whole room, had county maps, charts, told everyone your land was misfiled decades ago and should have always been inside the community boundary. I said nothing. She told them you'd probably settle quietly. Said most landowners in your situation do once they understand the legal exposure. The third letter arrived 2 days later. Attorney letterhead. Formal proceedings under expanded jurisdiction statutes. And at the bottom, the board had voted unanimously, every single member, to pursue legal boundary clarification. Not one person in that room stopped to ask whether they actually had the legal authority to claim 85 acres from a retired couple. Not one. That's the thing about group arrogance. Nobody pumps the brakes. I sat at the kitchen table for a long time that night. Outside, the orchard was quiet and dark. The same rows my grandfather put into the ground during the worst years this country ever saw. The same fence lines my father walked every morning. For 30 years, and Diane Holcroft had told a room full of strangers it was available for community apple picking. That's when I stopped arguing and started digging, because what I found in those county archives, she never saw coming. Not even close. I didn't call a lawyer first. Most people would have. And honestly, most people probably should have. But I spent 38 years as a civil engineer. I've read more property documents, boundary surveys, and county plat maps than most attorneys have. So before I paid anyone $300 an hour, I wanted to understand exactly what Diane Holcroft thought she had. I pulled out her letters, all three of them, spread them across the kitchen table, and read every word slowly. Not as an angry neighbor this time, but as a professional. Every single threat, every boundary claim, every mention of expanded jurisdiction and community compliance traced back to one document, Amendment 14-C. She referenced it 9 times across 3 letters. And not once, not in a single envelope, had she ever attached a copy of it. She was counting on me not to look. The county archives. The next morning, I drove to the county recorder's office. Quiet building. Fluorescent lights. Old carpet. The smell of documents that haven't moved in decades. The kind of place most people only visit when something has already gone wrong. I asked the clerk for everything on file for my parcel, going back to original title. She looked at me over her reading glasses, typed slowly, and disappeared into the back. She returned with a folder nearly 2 inches thick. You've got a lot of history on this. One, she said. I sat down at a reading table and started from the very beginning. And right there. On the first page, my grandfather's name, handwritten in faded ink on a 1937 deed. I remember running my finger across his signature. The same man who cleared that land with a mule. The same man Diane Holcroft had never once considered when she drew her little boundary lines. I kept reading. Every transfer, every survey, every recorded easement, decade by decade. Building the full picture. Then the first document stopped me cold. I leaned back in that chair and just sat there for a moment. Because I realized that Diane Holcroft had either done no research whatsoever or far too much, and was hoping I'd done none. It was a boundary survey from 1948, conducted by the county itself, not a private firm. It established my eastern and southern property lines with precise legal descriptions. Descriptions that matched my current deed exactly, down to the inch. Every time Diane had used the phrase expanded jurisdiction in those letters, she'd sounded so certain, so rehearsed, standing at my gate with her tabbed clipboard and her laminated badge. That confidence looked very different now, because those lines had never moved, not in 1972, when the county rezoned the surrounding area, not in 1989, when the road was widened, and not in 1996. And here's where it got interesting, when the Sunridge subdivision was platted. I found that document near the bottom of the stack, the original Sunridge development plat, recorded with the county in 1996. I spread it flat on the table under the fluorescent light and traced the boundary with my finger dot. My property was explicitly shown as excluded for their footprint. In writing, with a notation, stamped and officially filed by the same county recorder's office. I was sitting in right now. Somebody on that HOA board had either never looked at this document or they had and decided to move forward anyway. And suddenly, that sentence buried on page 2 of Diane's original letter started making a lot more sense. I photographed everything. Then I looked up at the clerk. One more thing. Amendment 14C, Sunridge HO expansion filing, about 80 months ago. Do you have anything recorded under that name? She typed, waited, typed again, frowned slightly. I am not finding a properly recorded Amendment 14C under that designation. She turned the monitor toward me so I could see for myself. Nothing. No filing number. No recorded date. No county stamp. This wasn't just a OA arrogance anymore. Diane Holcroft had built her entire legal threat, the letters, the attorney, the board vote. The surveyors on my land, on a document the county had never officially recognized, and she was still pushing forward, which meant one of two things. She didn't know, or she did know and was betting everything that I never would. Either way, I wasn't done digging, not even close. I hired one person before I hired a lawyer, a title researcher named Gerald Foss, retired county surveyor, 34 years on the job. The kind of man who keeps his own copies of plat maps because he stopped trusting other people's filing systems sometime around 1987. My former colleague recommended him with 4 words. Gerald finds everything missed. I handed him the full county archive folder, Diane's 3 letters, the 1948 survey, the 1996 Sunridge plat, everything I had. He called me 5 days later. And he didn't open with the answer, he opened with a question. Ray, when you went through that archive folder, did you pull the 1961 easement agreement attached to your southern boundary? I told him I'd seen an easement record but hadn't fully reviewed it. At first, I thought it was just a standard access notation, Gerald said. Then I saw the county statute attached to it. Ray, this easement has automatic penalty provisions. The moment anyone files a formal boundary claim against this parcel without prior county authorization, and I mean the moment they file, they trigger mandatory liability. Under that statute, I asked him what that meant in plain language. It means Diane Holcroft didn't just have a weak case. She walked into a legal trap that's been sitting quietly in the county records for 63 years. And the unauthorized survey her people ran inside your fence line, that made it worse. That added a separate trespass liability on top. I sat with that for a long moment. The title search didn't. Expose me, gotta exposed her. Thursday morning, February. I arrived at the courthouse. Early. Gerald sat to my right with a 2-inch binder, color tabbed. Every document cross-referenced. Helen Marsh sat to my left. Quiet, precise, 20 years in property law, with a binder even thicker. She'd said almost nothing to me since we sat down. She didn't need to. Diane Holcroft arrived with 2 board members and their attorney, a man named Purcell who carried himself like someone used to winning on paperwork alone. Diane was dressed sharply, composed. She scanned the room when she entered, found my eyes briefly, and looked away. She still had the clipboard. Judge Kavanaugh came in without ceremony, sat down, and looked at his pre-filed documents for nearly a full minute without speaking. Then he looked up at Purcell. Counsel, show the court a properly recorded copy of Amendment 14C as filed with the county recorder's office. Purcell opened his folder, paged through it, paged back. Your Honor, the amendment was formally adopted by the full HOA board and distributed to affected residents, recorded with the county. The judge repeated, same tone, not louder. Just final. Purcell glanced back at Diane. She leaned forward slightly and said something under her breath. He turned back. Your Honor, under HOA governance statutes, internal board amendments carry equivalent standing to. They do not, Judge Kavanaugh said. Not for boundary reclassification. Not in this county. Not under any statute I'm aware of. Do you have a recorded filing or not? Silence. That's when Diane did something that surprised me. She leaned forward and spoke directly, not to her attorney, but toward the bench. Your Honor, the board conducted a full review. We had survey data. The county maps clearly support the expanded boundary. We followed every internal. Ma'am. The judge looked at her steadily. You are not counsel in this proceeding. She sat back. One of the board members beside her stared straight ahead. Helen slid our documents forward without a word. Quiet, methodical, like she'd done this 100 times. Because she had the 1937 deed, my grandfather's signature, the 1948 county boundary survey establishing lines that had never legally moved, the 1996 Sunridge development plat, my property explicitly excluded, stamped, filed, sitting in the same recorder's office Diane had apparently never visited. Then Gerald's report, the 1961 easement, the attached statute, the automatic penalty provisions and last, the unauthorized survey, 2 men in yellow vests inside my fence line. Ordered by the HOA, documented. The judge read in silence for several minutes. Helen spoke for the first time. Your Honor, we direct the court's attention to Section 7 of the 1961 easement agreement, specifically the penalty clause on page 4. Under County Statute 18-441, any formal boundary claim filed against a parcel carrying this easement designation without prior written county authorization triggers mandatory liability at the time of filing. The HO filed on October 14th. The penalty clock started that morning. She paused. The unauthorized survey conducted on my client's property 9 days prior constitutes a separate trespass under statute 22-117. That liability accrued independently. Purcell was writing fast. Diane was very still. The judge looked up from the documents and focused on Purcell with an expression that wasn't quite anger, more like a man recalibrating his opinion of another man in real time. Counsel, are you telling me your clients filed a formal legal boundary claim against the parcel with a recorded protective easement, sent unauthorized surveyors onto that property without permission, and based the entire action on an HO amendment that was never recorded with this county? Purcell opened his mouth, closed it, and I see here, the judge continued, turning a page that in the original notice letter, your clients claimed, and I want to make sure I'm reading this correctly. He paused, Seasonal community enjoyment rights over an active agricultural orchard. He looked up. This court is not aware of any statute granting community apple picking rights. The room was completely silent. One of the board members put his head in his hands. The number judge Kavanaugh read the line items aloud, slowly. Statutory penalties under the 1961 easement clause triggered at filing. Diane stiffened almost imperceptibly. Court filing costs and administrative fees. The board member beside her shifted in his seat. Attorney fees. Helen's full billing. Recoverable under fraudulent claim statute. Purcell stopped writing. Trespass liability for the unauthorized survey. Diane's jaw tightened. Title correction and re-recording. Fees to formally strike the HOAS boundary claim from the county record. The judge set the papers down. Total damages, fees, and statutory penalties come to $67,240. He looked across the room. Payable by Sunridge Community. I'll also note for the record that the original boundary lines established in 1948 remain legally unchanged. This matter is closed. Diane Holcroft stared at the table in front of her. The clipboard was still in her hands. After the HOA never issued a public statement admitting wrongdoing. That's worth saying plainly, because real life rarely wraps that cleanly. Some Sunridge residents blamed Diane. Others blamed the board for following her without asking harder questions. A few quietly blamed the whole situation on outside landowners, which told you everything about how some people process being wrong. But Diane resigned from the board 6 days after the hearing. The two board members who'd sat beside her stopped attending meetings within the month. By spring, 4 of 7 board seats were vacant. The HOA hired an outside management firm and sent adjacent landowners a written notice. Careful legal language, no apology exactly, but an acknowledgement that the expansion boundary claims had been resolved in favor of the existing deed. Holders, Tom Briggs read his letter twice and called me. That's the most words I've ever seen used to avoid saying. Sorry, he said, dot the orange flags. We're gone from my fence line before the week was out. The eastern access road stayed open. That October, the harvest ran the same as it always has. Carol, and I walked the rows on a Sunday morning in late autumn. Cold air, heavy trees, the smell of apples and turned earth, and something that doesn't have a name but feels like time moving in the right direction. My grandfather put his name on a deed in 1937 and trusted that the record would hold. It held. Turns out land records don't care how loud someone talks at HOA meetings. They don't care about laminated badges or unanimous board votes or carefully tabbed clipboards. They just sit in a county archive, perfectly quiet, for decades, waiting for the day someone finally comes looking. I came looking. If you've stayed with this story until the end, I want you to sit with something for a moment, because this wasn't really about apples. It wasn't about one difficult woman with a clipboard. It wasn't about HOA meetings or survey flags or legal letters with impressive sounding language. This was about something much older than of that. My grandfather never went to college. He never hired an attorney. He never sat in a courtroom. He just put his name on a piece of paper in 1937, put his hands in the ground, and trusted that what he built honestly would be protected honestly. He was right. And here's what. $67,000 actually bought, not for me, but for Diane HOCROFT. It bought her a lesson that no HO meeting, no county map, and no laminated badge could have taught her. That confidence without knowledge is just noise. She walked onto my property with absolute certainty. She stood in front of a room full of neighbors and told them the land was hers to reassign. She sent attorneys. She sent surveyors. She sent 3 certified letters, written in language designed to make her retired. Couple feel small and outnumbered and defeated, and not once did she walk into a county recorder's office and look at the actual record. That's the real lesson here, not just for HOA boards, not just for neighbors with boundary disputes. For all of us, the loudest person in the room is rarely the most prepared person in the room. Power that isn't built on something real doesn't last. It just makes noise until the day it meets something solid. In this case, that solid thing was a 1937 deed, a 1948 survey, a 1961 easement, and one retired civil engineer who knew exactly where to look. There's also something worth saying about records, about documentation, about the quiet habit of keeping things in order, deeds, receipts, agreements, boundaries, not because you expect trouble, but because life occasionally sends trouble whether you expect it. Or not. My father kept a ledger going back to 1952. Every transaction, every survey update, every boundary note. I used to think it was just an old man's habit. It was armor. Keep your records, know your boundaries, and never assume that someone who sounds certain actually is. Because sometimes the most powerful thing you can do when someone shows up at your gate with a clipboard and a smile that doesn't reach their eyes is simply go find the truth before they expect you to. The truth was in a county archive the whole time, 63 years, sitting quietly, waiting. When it finally walked into that courtroom, it didn't need to raise its voice. It just needed to be read aloud. If this story meant something to you, share it with someone who needs to hear it. And if you've ever had someone try to take something that was rightfully yours, you already know exactly how this felt. Take care of yourselves. We'll see you in the next one.